Be ready. Start. In terms of the Statement of Objects and Reasons of the Act of 2002, it was stated that this law was enacted in order to make the government more transparent and accountable to the public. It was felt that in the present democratic framework, free flow of information for citizens and non-government institutions suffers from several bottlenecks, including the existing legal framework, lack of infrastructure at the grassroots level, and an attitude of secrecy within the civil services as a result of the old framework of rules. The Act was to deal with all such aspects. The purpose and object was to make the government more transparent and accountable to the public and to provide freedom to every citizen to secure access to information under the control of public authorities consistent with public interest in order to promote openness, transparency, and accountability in administration and in relation to matters connected therewith or incidental thereto. After the Act of 2002 came into force, there was a definite attempt to exercise such freedom, but it did not operate fully and satisfactorily. The Civil Services Conduct Rules and the Manual of the Office Procedure, as well as the Official Secrets Act 1923, and also the mindset of the authorities were implied impediments to the full, complete, and purposeful achievement of the object of enacting the Act of 2002, since, with the passage of time, it was felt that the Act of 2002 was neither sufficient in fulfilling the aspirations of the citizens of India nor in making the right to freedom of information more progressive, participatory, and meaningful. Significant changes to the existing law were proposed. The National Advisory Council suggested certain important changes to be incorporated in the said Act of 2002 to ensure smoother and greater access to information. After examining the suggestions of the Council and the public, the government decided that the Act of 2002 should be replaced, and in fact, an attempt was made to enact another law for providing an effective framework for effectuating the right to information recognized under the Article 19 of the Constitution. The Right to Information Bill was introduced in terms of its statements of object and reasons to ensure greater and more effective access to information. The Act of 2002 needed to be made even more progressive, participatory, and meaningful. The important changes proposed to be incorporated therein included establishment of an appellant machinery with investigative powers to review the decision of the public information officer, providing penal provisions in the event of failure to provide information as per law, etc. This bill was passed by both the houses of the parliament, and upon receiving the assent of the president on 15th June 2005, it came on the statute book as the Right to Information Act 2005. Now we may deal with the comparative analysis of these two acts. The first and the foremost significant change was the change in the very nomenclature of the Act of 2005 by replacing the word freedom with the word right in the title of the statute. The obvious legislative intent was to make seeking of prescribed information by the citizens a right rather than a mere freedom. There exists a subtle difference when people perceive it as a right to get information in contradistinction to it being a freedom. Upon such comparison, the connotations of the two have distinct and different application. The Act of 2005 was enacted to radically alter the administrative ethos and culture of secrecy and control the legacy of colonial era and bring in a new era of transparency and accountability in governance. In substance, the Act of 2005 does not alter the spirit of the Act of 2002, and on the contrary, the substantive provisions like sections 3 to 11 of both the acts are similar except with some variations in some of the provisions. The Act of 2005 makes the definition clause more elaborate and comprehensive. It broadens the definition of public authority under section 2H by including therein even an authority or body or institution of self government established or constituted by a notification issued or order made by the appropriate government, and includes anybody owned, controlled, or substantially financed by the government, and also non-governmental organization substantially financed by the appropriate government directly or indirectly. Similarly, the expression right to information has been defined in section 2J to include the right to inspection of work, documents, records, taking certified samples of material, taking notes and extracts, and even obtaining information in the form of floppies, tapes, videos, cassettes, etc. This is an addition to the important step of introduction of the central and state information commissions and the respective public information officers. Further, section 4(2) is a new provision which places a mandatory obligation upon every public authority to take steps in accordance with the requirements of clause B of subsection 1 of that section to provide as much information suo motu to the public at regular intervals through various means of communication including internet, so that the public have minimum resort to use of this act to obtain information. In other words, the aim and object, as highlighted in specific language of the statute, is that besides it being a right of the citizenry to seek information, it was obligatory upon the state to provide information relatable to its functions for the information of the public at large, and this would avoid unnecessary invocation of such right by the citizenry under the provision of the Act of 2005. Thank you.